Has the time finally come for the Supreme Court to rein in these so-called progressive states that ignore the Bill of Rights? Are we about to see a showdown that could reshape our understanding of the Second Amendment forever? In this video, we'll talk about how a bold statement from Supreme Court Justice Clarence Thomas could change the way we look at gun rights, and how it just might put Hawaii's controversial licensing scheme in the crosshairs. Now, before we dig into the nitty-gritty, let me lay it out plain and simple. The government doesn't get to decide whether or not we're worthy of exercising our rights under the Constitution. Our founders believed that our rights, especially the right to keep and bear arms, are inherent, fundamental, and unalienable. Yet here we are, watching a state effectively turn a God-given liberty into a privilege that must be earned, bartered for, and rarely granted. If you're curious about what happens when a state tries to override the very essence of the Bill of Rights with cultural platitudes, buckle up. We're peeling back the layers of Wilson v. Hawaii, where the so-called spirit of Aloha got thrown up as a smokescreen to undermine the Second Amendment. By the end of this video, you'll see exactly why Justice Thomas slammed Hawaii's approach, how it could affect gun owners nationwide, and why your vote, your voice, and your vigilance matter now more than ever. And here's a question you might be asking yourself. Could the Aloha state's approach become the new blueprint for anti-gun activists? Hang tight, because the answer may surprise you. Let's get going. Christopher Wilson's story begins in 2017, when he took a seemingly harmless hike that ended up costing him more than just time on the trail. While wandering around near private property, Wilson had a loaded firearm on him, but crucially, he didn't have one of Hawaii's nearly impossible to obtain concealed carry permits. The authorities wasted no time in slapping him with a criminal trespass charge and, more seriously, a firearm-related offense for carrying without a license. What's important to note here is that the licensing scheme in place was may issue, meaning the local police chief held nearly unchecked power to approve or deny firearm permits based on whether an applicant could demonstrate some exceptional case of personal risk. If that sounds ridiculous, that's because it is. Imagine telling a person who fears a violent stalker that they need to prove they're in an exceptional case before carrying a tool for self-defense. Then, imagine that same person discovering that for years, the local authorities have approved basically nobody's permit requests, even though Hawaii is home to over 1 million residents. In fact, between 1996 and 2017, Hawaii's counties issued a grand total of, listen to this, just 6 concealed carry licenses to private citizens. You heard that right, 6 in 2 decades. That's not a licensing process, that's a systemic blockade. So when Wilson found himself charged, he had reason to believe Hawaii's approach wasn't just strict, it was outright unconstitutional. The trial court initially sided with him and tossed the gun charges, but Hawaii's Supreme Court saw it differently, reinstating the charges and claiming that the spirit of Aloha outweighed his Second Amendment rights. That's where things got heated, and why this case ended up catching the eye of legal scholars, pro-gun advocates, and eventually Justice Clarence Thomas himself. But going back to Hawaii's highest court invoking the spirit of Aloha to justify restricting Wilson's gun rights, you just can't help but ask, are we really at a point where a state can wave a cultural slogan and override the country's Bill of Rights? Sure, culture and tradition are vital. They give communities their unique identity and values. But when that culture is weaponized to limit a fundamental constitutional guarantee, that's an entirely different story. It's akin to saying, we have a state tradition of politeness, so we can muzzle your free speech if we think it's too rude. You don't have to be a constitutional lawyer to see the problem there. According to the Hawaii Supreme Court, carrying a firearm without going through their labyrinth of regulations didn't align with the spirit of a peaceful, harmonious Hawaii. That reasoning might sound appealing on the surface, but it quickly falls apart under scrutiny. The Constitution doesn't magically vanish the moment local culture or tradition says it's inconvenient. Our legal framework is built on the idea that constitutional rights form the very bedrock of American life. They can't be shoved aside simply because they clash with a state's self-image. So what did Clarence Thomas do? He made it crystal clear that Hawaii's stance treated the Second Amendment like a second-class right, subject to government whim. If you've read any of Thomas's opinions, you know he takes the Bill of Rights extremely seriously. He's never been one to let states cherry-pick which amendments get full respect and which can be restricted on a whim. From his perspective, and ours, It's stupid and idiotic to require someone to prove they're in danger before they can exercise a pre-existing guaranteed right. This collision between the spirit of Aloha and the text of the Constitution confirms the rot in progressive America, where certain regions push cultural or political justifications to skirt around the plain meaning of our founding documents. Resolving that tension is precisely why the Supreme Court exists. Now you might be wondering, if Hawaii's licensing regime was so blatantly unconstitutional, why didn't the Supreme Court just swoop in immediately? The short answer is timing. The Wilson case surfaced for Supreme Court review in an interlocutory appeal, meaning it wasn't fully resolved at the state level. The Supreme Court usually waits for a complete record before deciding whether to weigh in. Even so, Justice Clarence Thomas didn't remain silent. He issued a statement calling out Hawaii's Supreme Court for dismissing the essence of New York State Rifle and Pistol Association v. Bruin, a 2022 decision that struck down New York's proper cause requirement for carry licenses. In Bruin, the court confirmed that individuals don't need to prove a special need to exercise a basic constitutional right. That spelled big trouble for Hawaii's exceptional case language, but the Hawaii Supreme Court insisted Wilson lacked standing because he never applied for a license in the first place. Thomas blasted that logic, arguing that Americans shouldn't have to jump through useless hoops to challenge a law that's unconstitutional on its face. It's akin to saying you can't complain about an illegal search unless you let the police barge in first. While the Supreme Court declined to intervene immediately, Wilson's case could still return once lower courts wrap up. If that happens, we may see a decisive ruling that reminds states they cannot treat the Second Amendment like an optional add-on, regardless of local tradition or cultural pride. And let's not forget what Bruin has already done. It has compelled states like Hawaii, where permits were virtually non-existent, to start issuing them in far greater numbers. That seismic shift proves that a single Supreme Court ruling can upend decades of restrictive policies. For many, it's a sign the judiciary still has the will and the constitutional foundation to hold state governments in check. So how did we get to a point where a constitutional right is treated like a mere privilege? Personally, I think it goes back to the days of the Civil War, but that's a subject for another video. If you'd like to opine on the matter, feel free to sound off in the comments section. Hawaii's may issue system all but declares that gun ownership is a privilege. By requiring an exceptional case or proper cause, the state effectively tells citizens, "We won't trust you with this freedom unless you convince us otherwise." That flips the burden onto the individual, who has to plead for permission to exercise a right the Constitution already guarantees. Imagine if we forced people to show they're extra special before criticizing government policy or refusing a warrantless search. It sounds dystopian, but that's exactly how Hawaii's scheme operates. Supporters of restrictive gun laws often argue that more control leads to fewer crimes. Yet criminals, by definition, don't follow the law. They're not lining up to apply for permits. The only people truly impacted by such a scheme are the law-abiding, who face endless paperwork, high fees, and a near-certain denial. Meanwhile, the Bill of Rights wasn't drafted with footnotes that say, "except in states that think differently." Once you allow a fundamental right to be treated as a privilege, it loses its power as a check on government overreach. This is precisely why the framers enshrined the right to bear arms in the Constitution. They remembered what unchecked authority looked like under the British Crown. They wanted a citizenry capable of defending itself, both from everyday criminals and from the possibility of government tyranny. A right that can be withheld at will offers no real protection at all. It becomes a hollow shell, easily manipulated by those in power. For anyone underestimating the significance of Wilson versus Hawaii, think again. If Hawaii's stance is ultimately upheld, it could embolden other states to design their own may-issue frameworks, using local tradition or public safety arguments to dodge the Second Amendment. We're not just talking about a single outlier state with a particular cultural heritage. We're talking about a potential ripple effect that could undermine Bruin and every ruling that clarifies an individual's right to carry. Law is as much about precedent as it is about statutes. A bad decision in one jurisdiction can pave the way for similar decisions elsewhere. That's why gun rights groups and constitutional scholars are watching this case so closely. If Wilson ends up convicted under a licensing scheme that was nearly impossible to comply with, the message to other states is, If you can't ban guns outright, just make the permit process so ludicrously difficult that people give up. On the other hand, if Wilson ultimately prevails, it'll send a loud, clear signal that states cannot cloak themselves in cultural or public safety arguments to ignore Bruin or treat the Second Amendment as optional. It might also embolden more Americans to stand up against local regulations that infringe on their liberties. After all, the Constitution isn't a buffet line where states can pick and choose the rights they'll serve. It's the supreme law of the land, binding on every jurisdiction from Maine to Hawaii. And if one individual's battle can reaffirm that truth, it's hard to overstate the potential impact on everyone who believes in the right to self-defense. Now, you might be asking, what can you do if you're cheering for Wilson and fuming at Hawaii's top court? First, stay informed. Knowledge is power, and the more you learn about cases like Wilson versus Hawaii, the better prepared you'll be to hold your ground in debates and in the voting booth. Keep an eye on your local and federal officials. Their legislative agendas can defend your rights or quietly erode them. Second, think about supporting organizations and legal funds engaged in these court battles. Litigation isn't cheap, and neither is lobbying. Whether it's the Firearms Policy Coalition, Gun Owners of America, or your own local group, every membership, donation, or volunteer hour helps fuel the legal challenges that keep state overreach at bay. Finally, don't underestimate the power of your own voice. Speak up at local meetings, pen letters to your representatives, and share accurate information on social media. Public opinion can be a mighty force, especially when backed by facts, perseverance, and a deep-seated belief in individual liberty. At the end of the day, the Constitution isn't self-enforcing. It needs citizens who refuse to let any level of government whittle away the freedoms our founders fought so hard to secure. And that's it for this video. Wilson's case isn't done yet, but Bruin has already shaken up Hawaii's approach to issuing gun licenses. The shockwaves from that ruling continue to push back against states that try to treat the Second Amendment as a negotiable privilege. Sure, bureaucracies can move slowly, and court cases can drag on, but when enough people stand firm, long-standing policies that ignore our founding principles can and do crumble. Still, this story is bigger than Hawaii. It's about reminding every official, judge, and legislator that the Second Amendment is the law of the land, not a conditional courtesy. When the state steps between you and your most basic rights, it's up to the courts, and ultimately the people, to say no. Free societies thrive when citizens can protect themselves and hold government power in check. And that's precisely what the founders had in mind when they enshrined the right to keep and bear arms. Thanks so much for sticking around till the end. If you're into our content, please hit that like button, share this video with your Pro 2A friends, and don't forget to subscribe and ring that bell so you never miss an update. Your support helps us keep making more videos like this. Thanks again for watching.